Hi, Larry. My name's Mike. Wouldn't it be prudent for the Supreme Court to just say that in those 6 states where there are disputes that they have to have a re-election and make every individual vote individually, show up and show a driver's license or proper ID to finalize this thing and determine it? Because I think that would be the best way to determine the whole thing. Thank you. Bye.
888-971-SAGE, 888-971-7243. I am Larry Elder. We are ReliefFactor.com studio. Later on the show program, Jim Jordan about the Eric Swalwell Chinese spy story says, Democrats always get a defensive briefing. Republicans get set up. The FDA is about ready to vote on whether or not to approve the COVID-19 vaccine. We'll know that in a matter of minutes. We're also waiting on the Supreme Court to determine whether or not they're going to take up the case that's been filed by Professor John Eastman on behalf of the president. We'll talk to Professor Eastman in just a few seconds. 888-971-SAGE, 888-971-7243 is the number. More than 60% of the House Democrats have joined in support of the lawsuit, which means 126 members. That's around 65% or so of the entire House Republican conference is supporting the President Trump's attempt to overturn the former vice president's alleged victory in 4 states. We're going to talk to Professor John Eastman about that right now. He is, as you know, professor of law at Chapman University, former dean there. Please welcome back to the program, Professor John Eastman.
Larry, thanks so much for having me back on. I should make clear I'm representing the president here in my individual capacity and not in my capacity as a professor at Chapman.
Correct. Professor, why did you agree to take the case?
Well, I think it has merit. I've been looking a lot at the legal, the statutes in these 4 states that were violated by collusive suits by Democrat Party officials against friendly Democrat secretaries of state, such as Eastman in Pennsylvania. These statutes that were designed to help protect against fraud in the area of voting that we know is most subject to fraud, which is absentee balloting. And they just ignored those laws. They ignored signature verification requirements. In Wisconsin, they ignored voter ID requirements. And you know, it doesn't look right. The number of ballots that are affected by these violations of state law is much larger than the margin of error, margin between the 2 candidates.
Professor, in going over your 39-page lawsuit, it does not appear to me, unless I've missed it, you're making the allegation that I think Sidney Powell is making, and that is that the Dominion machines themselves were hacked and voting tallies were altered. You're not making that argument, are you?
We're not. Texas focused on this, and then the president, in its motion to intervene that I filed, focused exclusively on the violations of law. See, the Article 2 of the Constitution says the legislature have plenary power to decide the manner of choosing electors. And when non-legislative election officials in those states ignored those laws, they were violating the federal Constitution. It's a very clean, pure constitutional legal issue, and we don't have to get into the fight of, you know, whether the machines were tampered with or all of that, because it doesn't matter. The elections were illegally conducted, contrary to state law that was issued pursuant to authority from the federal Constitution.
Professor, I was pretty confident that the Supreme Court would take up the Pennsylvania challenge. They chose not to, or at least the emergency challenge. Maybe it'll be resubmitted and they may end up taking the case. But I was surprised they didn't take that case. And if they're not going to take that case, it seems to me it's even less likely the Supreme Court is going to take up your case.
Well, that case, you know, involved a very interesting issue of state law. Mm-hmm. Did state law allow only absentee ballots for specified groups, or could the legislature broaden that? Excuse me, Larry. And what was asked by Representative Kelly was an emergency injunction. That's a very rare thing. Mm-hmm. What Texas has asked for here is expedited review. And it's made a very compelling case that it has original jurisdiction, which some of the justices actually think is mandatory, state-on-state lawsuits, that the court has to hear them, whereas Representative Kelly is just kind of a normal cert petition and compounded by the request for very quick emergency relief, which the court almost never grants.
I'm talking to Professor John Eastman, who in his personal capacity is representing the president in joining the Texas lawsuit along with the 17 other state attorneys general and suing 4 states to overturn the election. Professor, what specifically are you asking the Supreme Court to do with these 4 states? Are you asking them to overturn their determination that the election was won for Biden and say it was won for Trump? What are you asking the 4 states to do?
No, we've made clear we're not asking the court to decide the election. All we're asking the court to do is to decide whether the significant violations of state law require that the state legislature look at what happened and determine whether those electors are validly certified. And reasserting that the primary authority here is not the Secretary of State or county election officials, but is the legislature of the state. And I think if the Supreme Court does that, these legislatures will recognize what constitutional authority they have. Mm-hmm. There has been a great deal of uncertainty about that.
Professor, the argument, of course, against it is that we have 50 different individual state elections. If a state does something, then any other state can argue that that state's maneuvers affected our state, so that every state can also make the argument that any time a state does something that that other state doesn't like, they have standing, in which case we'd have these kinds of lawsuits all the time. For that reason, I think a lot of people feel the Supreme Court is not going to touch this thing with a 10-foot rod.
Yeah, I think the Supreme Court's going to take it, given the seriousness of the issue, and I will distinguish all those other kind of cases you mentioned. The Supreme Court has frequently held, including in a case involving John Anderson's independent run for president back in 1980, that the election for president and vice president is unique. They're the only offices in the land where every state has a vote, and the court said in that case, that what happens in one state, if illegal voting occurs in one state, that has a direct effect on the validity of the votes in other states. And I think that makes this different than any of the other state-on-state concerns that you raised.
Okay, I'm going to ask the same question over again, Professor, so bear with me. Assuming the Supreme Court takes the case, what do you want them to decide? What do you expect they will decide?
Well, if they take the case, I want them to decide whether non-legislative officials altering state law is legally permissible. And if it's not, then we've got an unconstitutional election that occurred in these 4 states, and remand to the state legislature to exercise their authority, both under Article 2 of the Constitution and Section 2 of Title 3 of the United States Code, to determine now what ought to happen in the choice of electors.
When you say determine what ought to happen, what you're not providing them any guidance as to what you want to happen?
Well, of course, we would like the legislatures in these states to look at the data, the significant data of how just, statistically impossible what happened in several of these counties was, and then on their own assess, absent these illegal actions by our state officials, here's what our best prediction on the evidence we have of how the outcome of the election would have been. Mm-hmm. And if that means Trump would have won, to cast electors for Trump.
Finally, Professor, why do you suppose the Supreme Court did not take up the Pennsylvania case?
Well, because it was extraordinary relief in a cert petition mm-hmm. by a single member of Congress on an issue that is not at all clear to me was even violated. They may have just rejected the emergency nature of it, or they may have just rejected it, having a look at the merits. But it was a cert petition, which is entirely within the court's discretion on whether to take it or not. Mm-hmm. The Texas case is arguably a mandatory case for a matter of original jurisdiction.
And Professor, you're waiting, I assume, any moment now to learn whether or not the Supreme Court is going to take up the case, correct?
Yes, at any moment.
Are you going to argue it if they do?
Well, it depends on what they do with President Trump's intervention.
Got to go. Thanks, Professor.
Texas.